Lawton, Oklahoma, thanks for the points, and we'll get some more calls a little later on our Washington Journal program as we continue to watch the scene from 2141 Rayburn, House Office Building on Capitol Hill, as some of the staff members get the room ready for tomorrow morning's hearing, which begins at 9 a.m. Coming next, we're going to re-air today's events. We'll begin with that presentation by the Democrats' lead counsel, Abby Lowell. And then at around 12:15 a.m., we'll show you David Schipper's remarks. He's the Republican Chief Investigative Counsel. He spoke for a little less than 3 hours. Tomorrow morning on our Washington Journal program, we'll have lots more of your calls, as we said. It begins at 7 a.m. Eastern Time. One of our guests will be the House Judiciary Committee's clerk, Sean Friesen. He'll discuss his position on the committee and his experiences. Washington Journal starts live at 7 a.m. Eastern here on C-SPAN. And as we mentioned, we'll have live coverage of the Judiciary Committee as they reconvene at 9 o'clock tomorrow to continue work on the articles of impeachment. Members will finish up their opening statements and then proceed to a markup session of the articles of impeachment. Committee may also vote on the articles later in the day. That all starts at 9. And again, if you'd like to read those articles of impeachment and look at other information regarding the hearings, you can check out our website, where you can also listen to or watch today's opening statements. You can see all of the hearings to date, in fact, on our website. It's at www.cspan.org.
Hi, I'm Barry Kerr, General Manager of TCI of South Florida, serving 138,000 customers in Dade and Broward counties. We're very pleased to offer C-SPAN to all of our customers.
C-SPAN. Created by cable, offered as a public service.
And now today's impeachment hearings. Coming up in just a few minutes, the House Judiciary Committee will hear from the Democrats' lead counsel, Abby Lowell. But first, Chairman Henry Hyde took care of some committee business related to today's hearing.
Committee will come to order.
There may be 8 Democrats who vote to more impeachment. We'll send George after. George will intimidate. Send George after.
The committee will be in order. Pursuant to notice, the committee will come to order to consider scheduled business. Today, we will hear presentations from Abby Lowell and David Schippers, and we will then consider articles of impeachment, and members will make opening statements. So we have a full, long day. Before I recognize the majority and minority counsels for their presentation, I must make the following unanimous consent request, which will allow both the Chief Democratic Investigative Counsel and the Chief Republican Investigative Counsel to thoroughly brief the committee. So without objection, I will make a unanimous consent request that refers to materials held in executive session. So without objection, so ordered. I ask unanimous consent
I object.
that, pardon?
I object.
Who's speaking? Ms. Lofgren?
I object.
You object to the unanimous consent request. Mr. Sensenbrenner.
Mr. Chairman, pursuant to Clause 2G1 of House Rule 11, I move to go into executive session to consider releasing certain executive session materials deemed necessary by the Democratic and Republican chief investigative counsels for their presentation.
The clerk will call the roll. You have heard the motion.
Mr. Sensenbrenner. Mr. Sensenbrenner votes aye. Mr. McCollum. Mr. McCollum votes aye. Mr. Geekus. Mr. Geekus votes aye. Mr. Coble.
Aye.
Mr. Coble votes aye. Mr. Smith.
Aye.
Mr. Smith votes aye. Mr. Gallagly. Aye. Mr. Gallagly votes aye. Mr. Kennedy.
Aye.
Mr. Kennedy votes aye. Mr. Inglis. Aye. Mr. Inglis votes aye. Mr. Goodlatte.
Aye.
Mr. Goodlatte votes aye. Mr. Booyer. Mr. Booyer votes aye. Mr. Bryant. Mr. Bryant votes aye. Mr. Shabbat.
Aye.
Mr. Shabbat votes aye. Mr. Barr.
Aye.
Mr. Barr votes aye. Mr. Jenkins. Mr. Jenkins votes aye. Mr. Hutchison.
Aye.
Mr. Hutchison votes aye. Mr. Pease.
Aye.
Mr. Pease votes aye. Mr. Cannon. Mr. Rogan.
Aye.
Mr. Rogan votes aye. Mr. Graham.
Aye.
Mr. Graham votes aye. Miss Bono.
Aye.
Miss Bono votes aye. Mr. Conyers. Mr. Conyers votes aye.
He voted no.
Mr. Conyers votes no. Mr. Frank. Mr. Schumer. Mr. Berman. Mr. Boucher. Mr. Nadler.
No.
Mr. Nadler votes no. Mr. Scott. Mr. Scott votes no. Mr. Watt.
Aye.
Mr. Watt votes aye. Ms. Lofgren. Ms. Lofgren votes no. Ms. Jackson Lee.
No.
Ms. Jackson Lee votes no. Ms. Waters.
No.
Ms. Waters votes no. Mr. Meehan. Mr. Meehan votes no. Mr. Delahunt.
Aye.
Mr. Delahunt votes aye. Mr. Wexler.
Aye.
Mr. Wexler votes aye. Mr. Rothman.
Aye.
Mr. Rothman votes aye. Mr. Barrett. Mr. Barrett votes aye. Mr. Hyde.
Aye.
Mr. Hyde votes aye.
That was a vote from
The gentleman from Massachusetts.
Mr. Frank votes aye.
What did he vote?
That was.
What did he vote?
Barney. There's a Barney or something.
Mr. Chairman, there are 26 ayes and 7 noes. Mr. Chairman?
The gentleman from Michigan. Gentleman wishes to change his vote to aye.
Mr. Conyers is recorded as an aye.
Mr. Meehan.
Mr. Meehan is recorded as an aye.
Are there anyone else wish to change their vote? I don't see him, no. Mr. Berman wish to vote? Mr. Berman votes aye. Well, the clerk will report.
Mr. Chairman, there are 29 ayes and 5 noes.
And the motion is agreed to. The
Mr. Chairman?
unauthorized people will have to
Mr.
leave
Chairman?
the room. We'll have to pull the plugs on the cameras.
Chairman?
Yes. Yes, Mr. Nadler.
I'd like to make my usual motion that the text of the motions and the ayes and nays during the executive
That's
session
the
be...
gentleman's not recognized for that purpose. The motion
Hey,
has
Mr. Chairman, I think I was recognized.
Well, you're unrecognized. The motion has carried. We now must go into executive session, and all unauthorized
Mr.
people
Chairman,
will leave the room, and we'll pull the plugs on the lights and the cameras.
point of order, Mr. Chairman.
We're not
Point of order, Mr. Chairman.
After meeting in closed session for about an hour, the committee reconvened to hear a presentation by the Democrats' lead counsel, Abby Lowell. This portion's 2 hours.
To order. I wonder if we could get the doors closed. Now, the chair would like to announce that what we plan to do today is first hear from Mr. Abby Lowell, the Chief Investigative Counsel for the minority. His presentation will take about 2 hours, I am informed. There is no time limit, whatever time he wishes he may have. If it is 2 hours or so, we will then take a lunch break, and at 2 o'clock, Mr. Shippers, David Shippers, the Chief Investigative Counsel for the majority, will make a similar presentation. That is to say, a summing up of where we are and what the evidence is and what positions they believe we should adopt. That should take 2 hours also, again, without any firm timeline. When that is over, both presentations are made, we will then go into a markup session on articles of impeachment. Now, preliminary to the actual markup, we will have opening statements. And throughout this process, we have been limiting opening statements to Mr. Conyers and myself simply because of the crowded agenda that we have. But now that we're reaching the culmination of this committee's role in this impeachment issue, I think it's appropriate that the members have an opportunity to make an opening statement of some duration. And so we have determined that 10 minutes for each member, which could consume as much as 6 hours or more, but it is appropriate that the members be able to make a significant opening statement before we get into the actual markup. That is the consideration of amendments, if any, and the vote on the articles of impeachment. So, the schedule will be Mr. Abby Lowell, lunch, Mr. Shippers, opening statements. If we don't finish those tonight, and I can't imagine we will come back tomorrow morning at 9 o'clock, and we will conclude the opening statements. Then the articles of impeachment will be open for amendment at any point, as in any markup, and we'll continue with that. There is a resolution of censure text that has been circulated, and it is my intention that we will debate and consider that after we have finished with the resolution of impeachment and voted on that up or down. And there may be several votes on that because I believe there are four articles. So that's a general outline of where we are and where we're headed, so people who need to make plans can make them.
Mr. Chairman.
Who's seeking recognition? Mr. Scott.
Parliamentary inquiry, Mr. Chairman.
State your inquiry.
Mr. Chairman, I've had a motion pending for some time. I was wondering if you could inform me when it might be in order.
Well, the gentleman was really never recognized for that motion. It really is out of order now. I'd like to proceed with the hearing as we have noticed it up, which is with Mr. Lowell.
Well, Mr.
You
Chair,
and I can maybe over the lunch hour talk some more about it.
well,
I'm happy to talk.
the motion has been pending. Are you ruling it out of order, or it's not in order totally, or is it not in order now?
Well, it's not in order now, although if the gentleman wants to be heard, I'll yield to Mr. Conyers.
Could we meet immediately after this presentation with the chairman about,
I would be
about the
delighted
motion
to.
that I advocated very strongly yesterday?
I thought that in the last time this came up, that it would definitely come up, and I thought that you and the chairman had agreed.
Yes, sir.
And I would just like to just note that it is still pending,
Yes, sir.
and whenever the chairman is willing to take it up, we can take it up.
Thank you.
What we can do is after luncheon, I'll recognize you for making your motion, and we'll get a vote on it. All right? Mr. Nadler. Yes, Mr. Nadler.
Chairman,
what could you possibly want?
I just think it would be appropriate to announce in open session what the committee decided in executive session before Mr. Lowell started.
Well,
that the motion was approved with an amendment.
I don't know how interested people are, but my motion was ultimately agreed to, and the motion to divide was withdrawn. And so that was the result.
Well, Mr. Chairman, there's always a great deal of suspense as to whether or not motions you make will be approved by this committee, and we didn't want to keep people in that suspense.
I suppose you're right. I haven't given that a lot of thought. In any event, at long last, we're at the point where we will hear from the Chief Investigative Counsel of the Democratic minority, Mr. Abby Lowell. Mr. Lowell.
Mr. Chairman, Ranking Member Conyers, and members of the committee, on behalf of the minority staff, all of my colleagues who are in this room who have worked so hard over the last 3 months, I appreciate this chance to present our work. 2 months ago, on October 5th, you allowed us to address you on the issue of opening an impeachment inquiry, and we will be referring to parts of that presentation in order to demonstrate that this committee does not have constitutional grounds to put forward the impeachment of the President of the United States. This week, Mr. Chairman, you brought the committee's attention to and quoted historian Arthur Schlesinger from his 1980s book, which dealt with the type offenses that were in Watergate. Rather than using his quotes about those very significant excesses of President Nixon, I think it would be better to cite what Professor Schlesinger said on November 9th, right here, about the insignificant offenses of President Clinton. He said, lowering the bar for impeachment creates a novel, revolutionary theory of impeachment, which would send us on an adventure with ominous implications for the separation of powers that the Constitution established as the basis of our political order. It would permanently weaken the presidency. With the time I have today, Mr. Chairman, I would like to first set out the framework for an impeachment. In other words, I'd like to address the questions of what an impeachment is and what it is not. Second, I will take some time taking you through what you have designated as the evidence to demonstrate that there are no clear facts on which to base such an action. Third, I would briefly compare the facts against the constitutional requirements that an impeachment may proceed only for high crimes and misdemeanors and only on the basis of clear and convincing evidence. And fourth, I would like to further explain how the process used in this matter should cause this committee to have second thoughts about proceeding with the third impeachment in American history. There has been a lot of confusing talk about what an impeachment is. The minority staff has now poured over thousands of pages of constitutional history, legal articles, and testimony. And we can begin this day, Mr. Chairman, explaining what an impeachment is not. Impeachment is not a means to punish the president. Impeachment is not a means to send a message to our children that the president isn't above the law. There are better ways to do that. Impeachment is not a vote of confidence for independent counsel Starr. Impeachment is not a penalty for the president not answering the 81 questions as some of you would have wished. Impeachment is not a form of rebuke or censure for the president's conduct. In fact, impeachment is not about the president's conduct. It's about Congress's conduct. Just because the president might disgrace his office by his actions, and just because the independent counsel may have shown partiality and zeal in his investigation, this House can do better. The road to dishonor in office can end in this committee, in this room, on this very day. Because what an impeachment is, of course, is the single device to remove from the office the chief executive who you decide is constitutionally disqualified to serve, and by doing so, overturn 2 national elections. As many of you have said, it is the political equivalent of the death penalty. Back in October, Mr. Chairman, I think the committee was listening to one another. Some have said we no longer are. News reports indicate that a majority of the committee's Republicans have already stated publicly that they will support at least one article of impeachment. I hope these reports are not true and that these debates have some purpose. If the reports are true, however, I hope your colleagues on the House floor are still listening. In what minority and majority staff present to you today, we wish we could ask each of you to change places so that Republicans would hear the arguments as Democrats and Democrats hear them as Republicans. Others have noted the portraits behind you of the 2 chairs of this committee who have had the terrible burden of presiding over impeachment inquiries. Interestingly, the portrait of Chairman Hyde hangs over the Democrats, and that of Chairman Rodino hangs over the Republicans. This should be the model for today's events. We should see, if we can see, the issues through the eyes of the other side. Just this once. With that in mind, Chairman Rodino recently had the opportunity to reminisce about that day 24 years ago that the gavel was in his hand. I would like you to listen to what he said.
And we have to be fair, and we have to be perceived to be fair. So we sort of have to control ourselves.
We needed Republicans as well. The American people would not have accepted a vote that would have been purely a partisan vote, voting to impeach the President of the United States purely on partisan grounds.
Mr. Chairman, you echoed the same thoughts before the heat of the lights and the rhetoric in this room were turned on. In a January interview, you said that you were reluctant to begin hearings because committee Democrats would not for it. And you also said, quote, "At the end of the day, the Democrats have to agree. I would be loath to start something that I didn't think we could finish. And right now, I doubt that Democratic support would be present." We are all served to listen to what you and Chairman Rodino were saying. And we're also well served to listen to the country. During our November 19th hearing, Congressman Graham accurately stated, and I quote, "Without public outrage, impeachment is a very difficult thing. And I think it is an essential component of impeachment. I think that is something that the founding fathers probably envisioned," end quote. The public has been telling us for months, and in every way they possibly can, that they do not want to see a trial in the Senate where the issues will be about sex, and that they want there to be a censure or other alternatives to impeachment as the means to demonstrate that the president is not above the law. So before this week is out, I hope we listen to the wisdom of the nation as well. As we have participated in every hearing and listened to all the statements, it appears that many in the majority seem to be going out of their way to find reasons to impeach, when our history tells us it should be the other way around. To this end, the committee has been too willing to dilute the constitutional standard of what makes up a high crime and misdemeanor by equating a violation of a statute, even a criminal statute, to a violation of Article 2, Section 4. It has been too willing to lower the burden of proof to suggest that the House is nothing more than a grand jury seeking to find probable cause. It has been too willing to reverse the presumption of innocence so that you ask why the President has not called fact witnesses when that is the obligation of the committee. It has been too willing to water down these proceedings to compare an impeachment of our only elected president to those where one of 1,000 appointed federal judges is involved. And as Judge Higginbotham said, it has been too willing to liken an impeachment of a president to a perjury conviction by a basketball coach. The lowering of the bar, as Professor Schlesinger has described it, must not continue. One of the constitutional scholars from whom you heard, Professor Jack Rakove, defined it well when he said, quote, "Impeachment is a remedy to be deployed only in unequivocal cases where the insult to the constitutional system is grave." And in the most important part of what he said, he added, "It would have to be a high degree of consensus on both sides of the aisle, in Congress, and in both houses to proceed." Mr. Chairman, some have asked whether the role of the minority staff is the same as the President's counsel. It is not. We are not here to defend the President. He, better than anyone, has said that his conduct was not defensible, and he has apologized for it. We are here, however, to strenuously defend the requirements the Constitution poses on all of us before we would even consider the word impeachment. Our obligation is to leave Article 2, Section 4 the way we found it on November 9th. For the minority staff, resort to the impeachment process is like resort to that fire extinguisher behind the glass door with a big sign that reads, "Break only in case of emergency." We are asking you not to break the glass unless there is literally no other choice. From listening to our constitutional scholars, we learned that debates about impeachment are like the wall protecting the fort of the Constitution's separation of powers. The crack you put in the wall today becomes the gash tomorrow, which ultimately leads to the wall crumbling down. It is that serious. It is so serious that the wall was never even approached when President Lincoln suspended the writ of habeas corpus, nor when President Roosevelt misled the public about involvement in the Lend-Lease program, nor when President Reagan misled the country and Congress about involvement with Iran-Contra. So, members of the committee, before you stop listening to each other, consider that a House vote for impeachment, as Majority Leader Trent Lott said last week, requires the Senate to begin a trial. Unlike your proceedings, all senators would be involved to have to hear the real testimony of all the real witnesses, not a summary from a prosecutor. This would have to occur no matter how long it took on the floor of the Senate with the Chief Judge presiding. Are the issues of the President's conduct in the case so grave that you would doom the country to additional months of this ordeal and government paralysis on the slimmest of votes on the House floor and no likely conviction in the Senate? When Mr. Starr testified 2 weeks ago, I began to review his evidence with him, but I ran out of time. I would like to do that now. The majority would break that glass and vote 4 articles of impeachment, one based on the President's perjury in the grand jury, the second on perjury in the civil deposition, the third on obstruction of justice, and the fourth called abuse of power. Mr. Scott has pointed out time and time again that this process has been something of a moving target. First, with Mr. Starr proposing 11 grounds, then with Majority Counsel dicing those charges into 15, and now with the majority putting forth articles that basically match the three categories the minority staff summarized for you on October 5th, except that the grand jury and deposition statements by the president have been divided into two separate articles. At the end of this process, we are about where we started. If you'll turn to tab 1 in your exhibit books, it is a chart of how the articles describe the proposed allegations. Allegations on the articles of impeachment that the president lied about an improper sexual relationship, the president obstructed justice by asking others to conceal that improper relationship, that the president abused his office by taking other steps to conceal that same improper private relationship. No matter how they are dressed up, redivided, renamed, reorganized, or duplicated, they all have the same central point: the president's improper relationship with Miss Lewinsky, nothing more. Well, we're not quite where we are when we started off. It is a little odd for me to make a presentation about why there are no grounds for impeachment before the majority has set out why such articles might exist. Similarly, it is a little odd to have the president's counsel make a defense when the charges were given to him afterwards. Mr. Chairman, I ask you and the committee to note that as we get closer and closer to a day of great constitutional moment, votes on articles of impeachment, we have gotten farther and farther away from one basic constitutional requirement: notice of the charges. These draft articles that we all received last evening have Article 1 alleging that the president committed perjury or lied at the grand jury, Article 2, the same offenses for the civil deposition, Article 3, obstruction of justice, and Article 4, abuse of power. If you look as we did last night, we cannot find in these articles what statements the majority contends were lies. Instead of precision, there is the phrase in Article 1 that the president gave misleading testimony concerning, quote, the nature and details of his relationship, end quote. Article 2 reads no better. Mr. Chairman, I know you and the staff are trying to be fair, but how is it fair to make these kinds of unspecified charges in these halls, in the people's house, on something as grave as impeachment? We should be doing better than filing charges that would be thrown out for vagueness in every courtroom in the land. The decision to make these vague charges and to have me speak first leaves me no choice but to assume, and I hope my assumption is correct, that the phrases in the proposed articles match the original allegations made by Mr. Starr. However, I have to say, it would have been better if the articles had just said so. On October 5th, I described the process by which prosecutors pile on charges to make their cases more serious. With that in mind, Mr. Chairman, I asked how it makes things clearer for the committee and the House, for majority staff to have taken various charges and to have repeated them over and over again. For example, majority counsel has adopted the independent counsel's allegation that the president tried to influence Ms. Lewinsky to file a false affidavit, and they list it in proposed Article 3, Clause 1 as an obstruction of justice. Yet, I see that they have also included the exact same event, renaming it as perjury in Article 1, Clause 4, by listing it as something the president lied about in his testimony. Surely, the committee can see through this tactic. For a week or more, the majority has stated that the president or the minority did not call fact witnesses. Mr. Inglis repeated that charge to White House counsel Ruff yesterday. But in America, it should not have been our burden to do so. However, if it's fact witnesses you need, then it will be fact witnesses you get. Mr. Chairman, on behalf of the minority, I now call to the stand Monica Lewinsky, Betty Curry, Vernon Jordan, Linda Tripp, and the President of the United States. You see, their sworn testimony, contained in the same boxes on which Majority Counsel is relying to put forth articles of impeachment, actually proves the President's case. And this is what the witnesses have to say. With respect to the charge that the President lied about his relationship, even members of the majority, such as Mr. Graham, had stated that the President's answers to surprise questions in his deposition, consisting of gobbledygook definitions of the phrase sexual relations, should not be grounds for impeachment. Yet there apparently was a change of mind. The proposed articles of impeachment include 2 separate articles for the President's statements. So if you truly want to go forward on impeachment, based on what the President has admitted were strained and evasive answers to questions at the civil deposition, I thought you and the public should hear how this all first started. Even though Majority Counsel has told us that they want parts of President Clinton's deposition in that case released, I thought you should have the whole picture and hear the amazing exchange between 3 lawyers and a judge that went into the contorted definition of sexual relations at the Paula Jones deposition that has gotten us all here today. Please pay attention to how long all this takes and listen to how all of them, and especially Judge Weber Wright, accurately predicted that the twisted definition would create havoc and confusion. But as you watch and listen, remember this. On January 17th, when the deposition was taken, the Paula Jones attorneys in the room already had Linda Tripp and her tapes. They knew they were setting up the President. They knew that they were trying to create havoc and confusion. But the President, his counsel, the lawyer for Trooper Danny Ferguson, and federal Judge Weber Wright had no idea what they and Linda Tripp were planning. And so, when Judge Weber Wright concludes in the portion you are about to hear, quote, "If you want to know the truth, I'm not sure Mr. Clinton knows all these definitions. She could have not known how correct she was."
Sir, I'd like to hand you what has been marked Deposition Exhibit 1 so that the record is clear today and that we know that we are communicating. This is a definition of a term that will be used in the course of my questioning. The term is sexual relations. I will inform the court that the wording of this definition is patterned after Federal Rule of Evidence 413. Would you please take whatever time you need to read this definition, because when I use the term sexual relations, this is what I am meaning today. Is there a copy for the court? Would you pass that, please?
Your Honor, as an introductory matter, I think this could really lead to confusion, and I think it's important that the record be clear. For example, it says the last line, contact means intentional touching directly or through clothing. I mean, just for example, one could have a completely innocent shake of the hand, and I don't want this record to reflect. I think we're here today for counsel for the plaintiff to ask the President what he knows about various things, what he did, what he didn't do. But I have a real problem with this definition, which means all things to all people in this particular context.
I think wording of that is extremely erroneous. What the deposing attorney should be looking at is exactly what occurred. And he can ask the witness to describe as exactly as possible what occurred. But to use this as an antecedent to his questions, it would put him in a position, if the president admitted shaking hands with someone, then under this truncated deposition or definition, he could say or somehow construe that to mean that that involves some sort of sexual relations. And I think it's very unfair. Frankly, I think it's a political trick. And I've told you before how I feel about the political character of what this lawsuit is about.
Your Honor, may I respond?
You may.
The purpose of this is to avoid everything that they have expressed concern about. It is to allow us to be discreet and to make the record crystal clear. There is absolutely no way that this could ever be construed to include a shaking of the hand.
Well, Mr. Fisher, let me refer you to paragraph 2. It says contact between any part of the person's body or an object and the genitals or anus of another person. What if the president patted me and said I had to lose 10 pounds off my bottom? You could be arguing that I had sexual relations with him. Your Honor, this is going to lead to confusion. Why don't they ask the president what he did, what he didn't do, and then we can argue in court later about what it means.
Let me make a ruling on this. It appears that this really is not the definition of contact under Rule 413, because Rule 413 deals with non-consensual contact. This definition would encompass contact that is consensual. And of course, the court has ruled that some consensual contact is relevant in this case. And so let the record reflect that the court disagrees with counsel that this is not that this is about being the definition under Rule 413. It's not. It is more in keeping with, however, the court's previous rules. But I certainly agree with the President's counsel that that definition number 2 is too broad, and so is definition number 3. Definition number 1 encompasses intent, and so that would be, but numbers 2 and 3 are just too broad.
All right, Your Honor.
And number 1 is not too broad. However, so I'll let you use that definition as long as we understand that that's not Rule 413. It's just a rule that would apply in this case to intentional sexual contact.
Yes, Your Honor. And had I been allowed to develop this further, everyone would have seen that Deposition Exhibit 2 is actually the definition of sexual assault or offensive sexual assault, which is the term in Rule 413.
Your Honor, I object to this record being filled with these kinds of things. This is going to leak. Why don't they ask? They have got the President of the United States in this room for several hours. Why don't they ask him questions about what happened or didn't happen?
I will permit him to refer to definition number 1, which encompasses knowing and intentional sexual contact for the purpose of arousing or gratifying sexual desire. I'll permit that. Go ahead.
Mr. President, in light of the court's ruling, you may consider subparts 2 and 3 of Deposition Exhibit 1 to be stricken. And so when in my questions I use the term sexual relations, sir, I'm talking only about Part 1 and the definition at the bottom. Do you understand that, sir?
I do.
I'm now handing you what has been marked Deposition Exhibit 2. Please take whatever time you need to read Deposition Exhibit 2.
Well, Your Honor, again, what I am very worried about, Your Honor, is first of all, this appears to be I mean, what I don't want to do is have him being asked questions and then we're all ships passing in the night. They're thinking of one thing, he's thinking of another. Are we talking criminal assault? I mean, this is not what a deposition is for, Your Honor. He can ask the president, what did you do? He can ask him specifically in certain instances what he did. And isn't that what this deposition is for? It's not to sort of lay a trap for him. And I'm going to object to the president answering and having to remember what's on this whole sheet of paper. And I just don't think it's fair. It's going to lend to confusion.
All right. But do you agree with Mr. Bennett?
And I have one other point to add. This is almost like in a typical automobile accident where the plaintiff's counsel wants to ask the defendant, were you negligent? That's not factual.
Mr. Fisher, do you have a response?
Yes, Your Honor. What I'm trying to do is avoid having to ask the president a number of very salacious questions and to make this as discreet as possible. This definition, I think the court will find, is taken directly from Rule 413, which I believe President Clinton signed into law, with the exception that I have narrowed subpart 1 to a particular section, which would be covered by Rule 413. And I have that section here to give the president so that there is no question what is intended. This will eliminate confusion, not cause it.
Your Honor, I have no objection where the appropriate predicates are made for them to ask the president, did you know X? Yes or no? What happened? What did you do? What didn't you do? We acknowledge that some embarrassing questions will be asked, but then we all will know what we're talking about. But I do not want my client answering questions and not understanding exactly what these folks are talking about. Now, Your Honor, I told you that the president has a meeting at 4 o'clock, and we've already wasted 20 minutes, and Mr. Fisher has yet to ask his first factual question.
Well, I'm prepared to rule, and I will not permit this definition to be understood. Quite frankly, there's several reasons. One is that the court heretofore has not proceeded using these definitions. We've made numerous rulings, or the court has made numerous rulings in this case without specific reference to these definitions. And so if you want to know the truth, I don't know them very well. I would find it difficult to make rulings, and Mr. Bennett has made clear that he acknowledges that embarrassing questions will be asked, and if this is in fact an effort on the part of plaintiff's counsel to avoid using sexual terms and avoid going into great detail about what might or might not have occurred, then there's no need to worry about that. You may go into the details.
If the predicates are met, we have no objection to the details.
Your Honor.
It's just going to make it very difficult for me to rule. If you want to know the truth, and I'm not sure Mr. Clinton knows all these definitions anyway.
Mr. Chairman, I think it's worth repeating that in this, and I'm sorry for the length, 10 or 15 minutes of lawyers and judges trying to come up with the definition that has now brought us to this constitutional moment, does anybody in this room, does anybody in the United States have a clear conception of what the definition of sexual relations were if those three people and that judge in that context had to spend that much time getting to the point? Let me end by reminding you what the judge just ended by saying. It's just going to make it very difficult. If you want to know the truth, I'm not sure Mr. Clinton knows all these definitions anyway. To those who would impeach the president and condemn him for not being more forthcoming in that deposition, put yourself in his position on that day. He was being set up by the Paula Jones attorneys and Linda Tripp, who had met with the Office of Independent Counsel just the day before. He knew that there was some collusion going on to embarrass him, not about sexual harassment, but about a consensual affair. So his responses were an attempt to answer the questions evasively. In the 2020 hindsight of almost a year, we know he could have, should have, acted better. But are his responses to all those questions you put to White House counsel Ruff yesterday so hard to understand that you would impeach him for acting as anyone would in that circumstance? In his grand jury appearance, the president explained his situation on that very day. And when you listen to what he is saying and put it in the context of what you now know, what was happening behind the scenes with Paula Jones and Linda Tripp and the attorneys, any fair-minded person would see that these were not impeachable reactions to that set-up predicament.
No, sir. In the face of the Jones lawyers, the people that were questioning me, in the face of their illegal leaks, their constant, unrelenting illegal leaks, in a lawsuit that I knew and that by the time this deposition and this discovery started, they knew was a bogus suit on the law and a bogus suit on the facts. In the face of that, I knew that in the face of their illegal activity, I still had to behave lawfully. But I wanted to be legal without being particularly helpful. I thought that was what I was trying to do. And you're the first person who ever suggested to me that I should have been doing their lawyers' work for them, when they were perfectly free to ask follow-up questions. On one or two occasions, Mr. Bennett invited them to ask follow-up questions. It now appears to me they didn't because they were afraid I would give them a truthful answer, and that there had been some communication between you and Ms. Tripp and them, and they were trying to set me up and trick me. And now you seem to be complaining that they didn't do a good enough job. I did my best, sir, at this time. I did not know what I now know about this. A lot of other things were going on in my life. Did I want this to come out? No. Was I embarrassed about it? Yes. Did I ask her to lie about it? No. Did I believe there could be a truthful affidavit? Absolutely. Now, that's all I know to say about this. I will continue to answer your questions as best I can.
You're not going back on your earlier statement that you understood you were sworn to tell the truth, the whole truth, and nothing but the truth to the folks at that deposition, are you, Mr. President?
No, sir, but I think we might as well put this out on the table.
Despite this context, the majority staff has decided to include the civil deposition as a separate article for impeachment, perhaps to add the appearance of more wrongdoing. But without this committee demeaning the impeachment process by exalting one answer, like, we were not alone, and then try to figure out whether it was all right to mean alone in the Oval Office, or alone in the pantry, or alone in the hallway, the context material we have just presented to the committee and to the public should put that attempt to rest and dispose of this article once and for all. This would leave as the core of the perjury allegations the charge that the president lied under oath at his August 17th grand jury appearance. These are vaguely described in Article 1. Mr. Chairman, how did we get to perjury, which is what Article 1 suggests? Independent counsel Starr's referral goes out of its way not to make a perjury charge, because that offense, as many of you on the committee who have been lawyers in the courtroom know, is one of the hardest to prove. On October 15th, majority counsel chopped and diced Mr. Starr's grounds into 4 others, but he too did not include one calling perjury. While the majority convened a perjury hearing a few weeks ago, many of the witnesses were in fact talking about other crimes. And as all the federal prosecutors who testified here said, this would never be a real case in a real court. So, if lawyers can conclude that this would not be charged as a crime, how do you as lawmakers allow it to be charged as a high crime? On October 5th, minority staff also suggested that the committee did not have to delve into the he said, she said salacious facts about this charge. Then, as now, The better approach would be to take the independent counsel at its charge. If it was President Clinton's lying about Ms. Lewinsky in the Paula Jones case that creates all of these impeachable offenses, then the committee and the House can resolve this issue by deciding the importance or impact of that statement in that specific case. I see in Article 2, the majority has put in the phrase, quote, deemed relevant when talking about the president's statements. And I certainly understand why they would want to have that phrase in the article. But they are obviously wrong. When Judge Weber Wright, if you look in your books to tab 2, and I'll put up the chart, ruled on January 29th that the evidence about Ms. Lewinsky was, quote, not essential to the core issues of the case, end quote, and might even be inadmissible, end quote. And when she made that same ruling on March 9th, 1998, and when she ruled on April 1st that no matter what President Clinton did with Ms. Lewinsky, Paula Jones herself had not proven that she had been harmed, she gave this committee the ability to determine that the president's statements, whether truthful or not, were not of the grave constitutional significance to support an impeachment. In any courtroom in America, so certainly in the halls of Congress, the president's misstatements about a consensual relationship made during a case alleging non-consensual harassment was not material then and are not grounds for impeachment now. But if reviewing the testimony in its proper context is not enough for the committee, and if it wants instead to go ahead with this article of impeachment, let us make sure that the committee, House members who will be voting on this on the floor, and the American people understand what will be the subject of a Senate trial. Again, putting aside the majority's attempt to list as perjury clauses that it makes in other places, there were 3 allegations of grand jury lies that I have to guess fit into the article's phrase about, quote, the nature and details of the relationship. They are first, as they were in the Starr referral, the date when the relationship began. Second, whether the president really believed that the term sexual relations did not include one type of sex. And third, whether the president touched Monica Lewinsky. As to the date when the relationship began, the actual charge is that Monica Lewinsky testified that the affair began in November 1995, but the president said it started in February 1996. How can you, in good faith, ask this nation to endure a Senate trial to determine the difference between 3 months? How much more trivial could an impeachment charge and a trial, let alone one paralyzing the Senate and the Supreme Court, possibly be? Mr. Chairman, you said during the perjury hearing that this article, this charge, quote, did not strike you as a serious count, end quote. And yet that is exactly what the independent counsel has charged, and that which majority counsel has now hidden in the vagueness of Article 1. The second allegation is that the president lied when he said his belief was that the phrase sexual relations as used in the Paula Jones deposition did not include oral sex. When many in the majority ask how we can condone perjury in our society, this is the lie about which they are talking. How would you have a trial in the Senate to conclude whether the president was right about what he thought the phrase sexual relations meant? You heard and saw the gyrations that it took 3 lawyers and a judge to deal with this silly expression. So who would you call to determine that the president did not believe in his interpretation? The answer is that you don't have to call anyone. You have enough information right now to conclude that such a trial is unnecessary. The video you saw proved that the term sexual relations was defined by Paula Jones' attorneys for Paula Jones's case. With that in mind, let me read what one of Ms. Jones's attorneys has said about that phrase when he appeared on MSNBC and was asked. Paul Camerata said, quote, "It is out of my definition of sexual relationships on a personal basis, and I think you have to understand the definition he was operating on when questioned," end quote. If Mr. Camerata, one of her lawyers, can understand that the phrase sexual relations can exclude certain types of sex, how does this committee, in good faith, base an article of impeachment on the president interpreting it in the exact same way. But there's more. Listen to the witnesses, Monica Lewinsky and Linda Tripp, before the independent counsel confronted her, before she went back and forth over an immunity agreement, and before this became so important that the definition of sex will sink us into a constitutional quagmire. Listen to the woman who you would have the United States Senate call as a witness as she defines the term in the exact same way you now accuse the president of lying about.
We didn't have sex, Linda. We didn't have sex.
Well, what do you call it?
We fooled around.
Oh,
Sex?
I don't know. I think if you get to orgasm, that's having sex.
No, it's not.
Yes, it is.
No, it's not.
It's not having
Sex is having intercourse.
Where is the impeachable offense when the president's testimony and Ms. Lewinsky's are the same? Is this what you are going to bring to the floor of the Senate? And so the perjury that some in the majority have said tears at the fabric of our judicial system comes down to whether the president lied about whether he touched Ms. Lewinsky. I suspect that that must be the nature and details allegation in Article 1. Mr. Chairman, no one, certainly not Congress, and certainly not Ms. Lewinsky and her family, wants to cause further embarrassment or loss of privacy to her. In short, no one wants to have her testify. Members of the committee, members of the House, before you force that terrible result, before you necessitate her testimony in the Senate, before you put the country through that unseemly spectacle of a trial requiring Ms. Lewinsky to describe what part of him touched what part of her, you must accept that such a trial, to defend the charge that you're putting forth about something called the nature and details of their relationship, necessarily would have to elicit prurient and salacious information. Such a he said, she said drama, if you really want it, would also have to include questions into the inconsistencies in Ms. Lewinsky's testimony that the independent counsel seemed to ignore in his referral. Mr. Goodlatte yesterday asked White House counsel Ruff about all the corroborating evidence, but I'm not sure what he meant. By way of example, do you want the Senate to be required to determine what Ms. Lewinsky meant when she said this about herself?
And I was brought up with lies all the time. So that was how you got along in life, was by lying.
I don't believe that. Is that true?
Yes, it's true. I wanted something from my dad. Well, once my parents were divorced, if I wanted money from my dad, I had to make up a story. When my parents were married, my mom was always lying to my dad for everything. Everything. My mom helped me sneak out of the house. I mean, that's just how I was raised.
As another example, do you want the Senate to have to examine various statements that Ms. Lewinsky made, as you now want to charge it about the, quote, nature and details of her relationship that are clearly erroneous? What do I mean? I mean statements like the one she made to her friend Kathleen Estep, that the Secret Service took the president to a rendezvous at her apartment. Or statements she made to friends Ashley Raines and Nasa Erbland that she had relations with the president in the Oval Office without any clothes. Or statements she made to the White House steward Biani Nelvis that the president invited her to go to Martha's Vineyard with him when the First Lady was out of the country. Or statements she made to New York job interviewers that she had lunched with the First Lady, who then offered to help find her a place to live in New York. Members of the committee, we know that none of those things happened because not even the independent counsel claims that they did. But that type of embellishment would require scrutiny in a Senate trial. If you really want to send that body that event, and if you really want to charge the president lied about the, quote, nature and details of Ms. Lewinsky and his private relationship. Is that what you want to put the country through? How do we justify an inquiry into these matters? And how do you justify to Ms. Lewinsky and to her family that after all they have gone through, you will subject her to the ordeal to resolve those issues? You can avoid this result by recognizing that the same inconsistencies which a Senate trial would have to explore also mean that the evidence available for you today to have to resolve this he said, she said conflict do not amount to the threshold of evidence required in the House to send charges to its sister body about something called the nature and details of the relationship. When he was here, look, for example, on page 58 of his testimony, Ken Starr said over and over when he was asked questions concerning the events at the Ritz-Carlton or about Ms. Lewinsky being asked to wire the president, that sometimes perceptions can be different without someone being called a liar. I think you can use Mr. Starr's admission in foregoing that spectacle that I have just explained would have to occur in a Senate trial. Finally, as to the article of perjury, some of the majority have now confused the three very precise allegations of lying in the referral with some general criticism of the president for stating that he didn't recall something or that he didn't remember the details of something. In fact, the majority staff has now included in Article 4 the charge that the president abused his power by such statements in his answers to the 81 questions that were posed to him. This allegation, however, was not what the independent counsel charged on September 9th. It was not what majority counsel alleged on October 5th. And it is a dangerous precedent. Given statements from President Roosevelt's failure to remember that he promised military support for Panama in its conflict with Colombia over the canal, to President Reagan's failures to remember how funds flowed to the Contras, this committee should not make presidential lapses of memory into impeachable offenses, or the office could go vacant forever. But now that the majority staff has included this as a charge, let me show you why this tactic and this charge is unfair for impeachment. Remember that despite being prepared for weeks for his appearance before this committee and having practice sessions with his assistants and knowing the criticisms about which he was going to be asked, this is how the prosecutor, whose material you have chosen to rely on, answered many of your questions.
I believe I'm recalling the one that you are speaking to. If my recollection serves me, I don't know whether there were 6 conversations. To the best of my recollection...
You did the first. You didn't do the second, did you?
Well, I would have to double check.
Did you discuss?
I am not recalling that.
Is there any possibility that the answer is yes?
I have no recollection of it, but I am happy to search my recollection. I do not have a recollection of that, but I am happy to now search my recollection.
The first question was, when did you first hear any information to the effect that a tape recording existed of a woman, any woman, who claimed to have had a sexual contact with President Clinton?
And I would have to search my recollection. I've prepared today for questions that go to this referral, so I will have to search my recollection.
Judge Starr, has your office interviewed or deposed Mac McClarty with regard to Filegate?
I cannot recall off the top of my head whether we conducted that particular interview or not.
It's either yes or no, not the legality.
I do not know. I know what Ms. Lewinsky has said. I would have to conduct an interview with my agents to know what the position of the office is. I would frankly have to search my recollections. I would have to search my recollection.
You denied Mr. Ginn.
Before this committee starts making the phrase, I don't recall, I don't remember, I'd have to think about it, something that you would bring to the floor of the Senate. See what an unfair tactic that really is. As to Article 2, alleging obstruction of justice, on October 5th, we recognized that the charge, reminiscent to Watergate, was the most egregious of the 4 grounds alleged in the Starr referral, and in majority counsels dividing those into 8 total charges. As they were presented by the referral, and again, I can only assume that is what the majority means in Article 3 of the proposed articles of impeachment, the charges are: first, the president tried to have Ms. Lewinsky submit a false affidavit. Second, the president initiated a return of gifts he had sent Ms. Lewinsky so they would not be discovered in the Paula Jones case. Third, the president sought to keep Ms. Lewinsky quiet with a job. And fourth, the president sought to tamper with the testimony of Ms. Curry. Let me turn to each in order, and rather than relying on conclusions and inferences from the Starr referral, let's listen to the actual witnesses. If you turn to tab 3 in your exhibits, we will put up the chart. As to the claim, the president did not seek that the president did not seek Monica Lewinsky file a false affidavit. With respect to this issue, both Ms. Lewinsky and the president agree with the very obvious point that she could have filed a completely truthful affidavit denying any sexual harassment and therefore avoided being called as a witness in the Paula Jones case. This is how completely the president explained this basic point.
I didn't know that Ms. Lewinsky's deposition wasn't going to be sufficient for her to avoid testifying. I didn't, so all these details.
You mean her affidavit?
Excuse me, I'm sorry, her affidavit, thank you. So I don't necessarily remember all the details of all these questions you're asking me, because there was a lot of other things going on, and at the time they were going on, until all this came out, this was not the most important thing in my life. This was just another thing in my life.
But Vernon Jordan met with you, sir, and he reported that he had met with Monica Lewinsky, and the discussion was about the lawsuit, and you didn't inform under oath the court of that in your deposition.
I gave the best answer I could based on the best memory I had at the time they asked me the question. That's the only answer I can give you, sir.
That tape, I think we've got one tape out of order, and I'll come back to that. What the president said was that Monica Lewinsky could file a completely honest and truthful affidavit in a suit about sexual harassment, saying she was not sexually harassed, and by doing so, hopefully avoid having to be deposed. Consider that Monica Lewinsky, in January 1998, in a conversation when Linda Tripp was wired, when speaking about her affidavit, Ms. Lewinsky, a sworn witness for this committee to consider, said, quote, "No matter how she was wronged, it was meaning Ms. Lewinsky's choice about the affidavit." Then members of the committee read what Ms. Lewinsky said the first time she ever came in to see the independent counsel, not after the sessions where they went over and over her testimony. She wrote in what the law calls a proffer the following statement, and I quote, "Neither the president nor Mr. Jordan nor anyone on their behalf asked or encouraged me to lie," end quote. You can find that in her February 1st, 1998 proffer statement that she gave to the Office of Independent Counsel, contained in the first appendix the committee issued in this matter. Add to your consideration Ms. Lewinsky's grand jury testimony about the affidavit when she stated that it could range between just somehow mentioning innocuous things to actually denying sexual relations as that term was defined. If you want, or if you need more evidence, you can find it in her August 6th grand jury appearance when she was the one who admitted that she, quote, would strongly resist, end quote, any attempt by President Clinton to make her reveal their relationship. Do you want more evidence? Then consider that on this all-important issue of the president apparently, supposedly telling Ms. Lewinsky to file a false affidavit, she testified that when she asked the president if he wanted to see the affidavit, the president, quote, told Ms. Lewinsky not to worry about the affidavit, end quote. And finally, listen to Ms. Lewinsky on December the 22nd, 1997, give you the most important statement, again, before she was confronted by the Office of Independent Counsel, made their witness, and given their immunity. As to the president wanting or knowing about her lie, this is what she told Linda Tripp. You told him you were going to lie, haven't you? No. By the way, the witness, Ms. Lewinsky, also was uncontradicted in the 17 boxes of information that it was she, not President Clinton, who undertook each and every one of these steps that went beyond merely trying to deny their improper relationship. She invented the code names with Betty Curry. She and no one else was responsible for the talking points. She, with the prodding of Linda Tripp, not the president, decided to hide her dress. And it was her idea to delete emails and files from her computer. For these acts, Ms. Lewinsky was given immunity, and the independent counsel and majority staff would have you vote that it was the president who obstructed justice. Before you do that, let me have you listen to another witness. I would like to recall independent counsel Starr to the stand so you can hear that the proof actually contradicts this article of impeachment.
Then as to the issue of the false affidavit, which you state was something the president was complicit in to the extent that it was a ground for impeachment, your evidence also includes, does it not, Mr. Starr, that Ms. Lewinsky gave you a statement in which she said, quote, neither the president nor Mr. Jordan or anyone on their behalf asked or encouraged her to lie. And you can find that in tab 35. Tab 35. 35. Thank you. You're aware that she has made the statement that way by now, I assume, right? Yes. You must be aware that she also said that she offered to show her affidavit to the president, but he did not even want to see it. You're aware that that's the testimony that she's given as well, correct? Yes. You must also be aware that she explained to you that the president and she had obviously used cover stories from the beginning of their relationship long before she was ever listed as a Paula Jones witness. You're aware of that as well, aren't you? Yes, and
But he went on to say, yes, and our referral includes that, but you got to look in the boxes. Certainly, the majority cannot claim to need a trial in the Senate for the issue of the gifts exchanged between the president and Ms. Lewinsky. If you turn to tab 4, there's a chart of the charge, and what we do in these charts, members of the committee, is we list all the contradictory evidence which undermines the charge. As to this one, rather than the president trying to hide or care about gifts, the witness, Ms. Lewinsky, admitted that she raised the issue with the president, not vice versa. She offered sworn testimony describing this conversation on at least 10 occasions. In 7 of these, including the very first time she saw the independent counsel and the last time she saw the independent counsel, she indicated that it was the president who never responded to this issue. In the only 2 of all of her statements does she even state the outrageous lines leading to this article of impeachment that all the president ever said on the subject of gifts were, when she raised it, about hiding them, giving them back, quote, I don't know, let me think about it. And then Ms. Lewinsky said, he left that topic. This is hardly the stuff of obstruction. The independent counsel chose to state the president's response without bothering to tell you and the American people about the other 9 times they asked Ms. Lewinsky the same question. Well, let's call Betty Curry to the stand. Let her be your witness you want to hear from. She stated repeatedly that Ms. Lewinsky called her and raised picking up the gifts. and that the president never asked her to call Miss Lewinsky. Here is her testimony. She was asked, and she said, "My recollection, the best I remember, is Monica calling me and asking me if I'd hold some of the gifts for her. I said I would." The question was, "And did the president know you were holding these things?" Ms. Curry answered, "I don't know." Independent counsel asked, "Didn't he say to you that Monica had something for you to hold?" Ms. Curry answered, "I don't remember that. I don't." That's in her grand jury testimony on May 6th. She was also asked by the independent counsel, "Exactly how did that box of gifts come into your possession?" Ms. Curry swore under oath, "I do not recall the president asking me to call about a box of gifts." Let me recall to the stand the president so that you can recall that it was he, not Linda Tripp, not Lucy Ann Goldberg, who gave Miss Lewinsky the proper advice.
All those things that have happened, I'm amazed. There are lots of times when I literally can't remember last week. The reason I'm not sure it happened on the 28th is that my recollection is that Ms. Lewinsky said something to me like, "What if they ask me about the gifts you give me?" That's the memory I had. That's why I question whether it happened on the 28th, because she had a subpoena with the request for production. And I told her that if they asked her for gifts, she'd have to give them whatever she had, that's what the law was.
He said, if they asked you about the gifts, you'd have to give them up. That's what the law is. Finally, the evidence is uncontradicted as evidence could possibly be that on December 28, 1997, the president gave Miss Lewinsky the most gifts he had ever given her on one day because of Christmas and Miss Lewinsky moving to New York. He did this after Miss Lewinsky had been subpoenaed for gifts, and yet this charge, your article of impeachment, would have you believe that on December 28th, he gave Miss Lewinsky the gifts, and a few hours later hatched some scheme and some conspiracy by asking Miss Curry to go and retrieve the very gifts he had just given. The independent counsel's charge and that clause in the article of impeachment defies logic. So let me ask this. Where does the majority expect to find the clear and convincing evidence that this obstruction concerning gifts occurred if it does not exist in the 9 grand jury and other appearances by Betty Curry, the 22 by Monica Lewinsky, and the 20 by Linda Tripp? What will you give the Senate trial to do? A damning allegation reminiscent of the worst of Watergate is when a president suborns perjury and another witness. That is what majority's proposed Article 3 suggests when it alleges that the president sought to influence the testimony of Betty Curry. But the actual evidence is not that the president was talking to Miss Curry as any potential witness, but that he was talking to his secretary about a media storm that was about to erupt. It is not surprising, improper, or impeachable for the president to want to hide his improper relationship and even hope that in conversations he might test what others knew about it. Yet this proposed article of impeachment alleges that which does not exist and literally impossible to prove, no matter whether a Senate trial would take a day or a year. On January 18, 1998, when the president called Ms. Curry for a meeting, there were days left in the schedule for taking any evidence in the Paula Jones case. And again, the majority staff couches their charge. The majority staff couches their charge as the president trying to influence, quote, a potential witness, end quote. But the plain, uncontradicted, and dispositive fact is simply this. Betty Curry was not listed as either a deposition or a trial witness in that case, and the article of impeachment is wrong to state the opposite. Some of you have asked, did it matter if the president said during his deposition, quote, "You will have to ask Betty Curry," end quote. But even after he said that, Ms. Curry was never added to any witness list, never contacted by the Paula Jones attorneys. And although the independent counsel interviewed the Paula Jones attorneys, they never asked them a question about Betty Curry becoming a witness. Do you want to know why? Because the answer that she was never contacted, never deposed, and never added to the witness list in any way, even after the president suggested that they talk to Betty Curry, destroys this subordination charge. Members of the committee, most of you, I think almost all of you, are lawyers. Your colleagues on the floor are going to be looking to you to give them guidance about the law. Certainly, for something as grave as an impeachment, do not rewrite 100 years of law. You know as well as I that there cannot be subordination of a witness unless the person involved is a witness. Ms. Curry was not, and this article of impeachment has no legal grounds on which to stand. Equally important, there is no need to waste the Senate's time with a trial, because President Clinton and Betty Curry, the only people involved in this event, both agree that the conversation on January 18th was not about testimony, was not intended to pressure her, and was caused by inquiries from the press, not any litigation. There has been so much misinformation about what was said between the president and Ms. Curry, including Mr. Graham's attempt to make this short conversation into some wild conspiracy to get Ms. Lewinsky, that perhaps it is best to let their own words speak for themselves. Let's recall the president to the stand first.
How did you making the statement, "I was never alone with her," right? Refresh your recollection.
Well, first of all, let's remember the context here. I did not at that time know of your involvement in this case. I just knew that obviously someone had given them a lot of information, some of which struck me as accurate, some of which struck me as dead wrong. But it led them to ask me a whole series of questions about Monica Lewinsky. Then on Sunday morning, this Drudge report came out, which used Betty's name, and I thought that we were going to be dead used by press comments. And I was trying to refresh my memory about what the facts were.
You want corroboration? Give you corroboration. Let's call Ms. Curry to the stand and see what she would say. She was asked the following question. You testified that he wanted you to say right at the end of those 4 statements. I was never alone, you know the 4 statements. This is what Ms. Curry said. I do not remember that he wanted me to say right. I could have said wrong. Independent counsel didn't like that answer, so asked, did you feel any pressure to agree with your boss? She answered, none. You can find that in her July 22nd, 1998 grand jury appearance. Finally, I would like to call one more witness. When Mr. Starr was here, this is how he resolved the issue completely for you in response to questions Senator-elect Schumer put to him.
And with respect to Betty Curry, I would simply guide the Congress again, the House again, to the substance of the president's testimony and how
She was injected into the matter by the president in his testimony, and we think that does have
With all due
significant...
respect, sir, that doesn't answer my question, which was
Sorry.
not how she was injected or what the substance was. Please, Mr. Chairman, he didn't answer my question directly, but how did you come to realize that the president knew that she would be called as a witness when there was no mention of it at that time? Is this just surmise, or do you have any factual evidence that the president knew that she would be called as a witness? We understand he wanted her not to tell the truth, but we don't know to whom. Where's your evidence?
The evidence is not that she was on a witness list. You're quite right. She was not on a witness list, and we've never said that she was. What we did say is that the transcript of the president's January 17 deposition shows that he was injecting Betty Curry into the matter and saying, may I finish?
Sure.
And saying specifically, you will have to ask Betty.
This committee does not have to go any further than the admission of witness independent counsel Starr to see that this charge too and this article may not go forward on the record. If there's no proof that the president had the wildest idea, even in spite of the invitation to do so, that Betty Curry would ever be contacted, would ever become a witness, would ever be deposed, then you have no choice on the record but to see the obvious conclusion that it was the Drudge Report, the media inquiries, and the president knowing that his deposition testimony was about to be leaked that caused all the events that you would impeach him over on a charge that does not exist. As to the fourth allegation about the job search, how can the majority cause the crisis a Senate trial would occur based on an article of impeachment alleging obstruction of justice by trying to get Ms. Lewinsky a job? Each and every one of you know that there is no contradiction by any witness. Not Linda Tripp, not Monica Lewinsky, not the president, not Betty Curry, not the White House staff, not Ambassador Bill Richardson and his staff, not even the New York interviewers, that the job search began long before Ms. Lewinsky was even a dream to the Paula Jones attorneys and had nothing to do with that case. How ironic is it that Linda Tripp went to see Ken Starr with a great tale about obstruction of justice, which you have now decided to adopt in your proposed article, and that this obstruction of justice was by Vernon Jordan, who she said was keeping Monica Lewinsky quiet by offering to help get her a job, when it was Linda Tripp herself and not the president who suggested that they get Vernon Jordan involved. We know now that Ms. Tripp owes Vernon Jordan an apology for that false charge, and she owes him one as well for this.
No, it'll be, if it goes to the civilian sector, it'll be Vernon being told this has to happen, him picking one of the names that he can eat, that he has a buddy, and he'll call and say she must be hired immediately. That's how that works.
The leadoff man, Devon White, went down swinging 4 times for...
And it's been known to work that way, so. It's just that right now I don't think he's aware of the whole situation.
No, he's not.
Right now, I don't think he's aware of the whole situation. No, he's not. Boy, Ms. Tripp, couldn't have said it any better myself. And finally, while it has been pointed out to the committee many times, it cannot be pointed out too often, because this statement by your witness, Monica Lewinsky, answers this charge about obstruction of justice and leaves this committee in the House with no proof. Ms. Lewinsky, even though never asked by the independent counsel, made sure she did not finish her grand jury testimony before stating, quote, "No one asked me to lie, and I was never promised a job for my silence." And you know where that one is all too well by now. Members of the committee, in light of this statement, where will you find the evidence of obstruction to send to the Senate? Let's listen to independent counsel Starr, who agrees.
As to the issue of whether or not she was given a job in some way to keep her happy, you know the evidence that you sent Congress includes the fact that the job search for her began long before she was listed as a Paula Jones witness, correct?
Yes, absolutely, and we make that clear in the referral.
And you are also aware that she told the president in July, months before the Paula Jones...
July of...
1997.
Yes, thank you.
Months before the Paula Jones case was an issue, that she was going to look for a job in New York.
Yes, she did.
And you're aware as well that it was Miss Tripp, not the president, Miss Tripp, who suggested to Miss Lewinsky that she bring Vernon Jordan into the process. You know the evidence says that, don't you?
I am aware of the evidence with respect to that, but yes, go right ahead. I'm sorry.
You're aware as well that the evidence you sent Congress indicates that on that crucial issue, as others have stated, and I'm no doubt will state again, Ms. Lewinsky unequivocally, even though never asked the question, stated to you that no one ever asked her to lie, no one promised me a job for her silence. You understand she swore to that as well?
Yes, and Mr. Chairman, may I respond? I'm trying to be brief, but Mr. Lowell, as you also know, at page 174 of our referral, we specifically say, Ms. Lewinsky has stated that the president never explicitly told her to lie.
You find trial material in any contradiction in the evidence on this? Speak to your colleagues in law firms and law courtrooms all over the world. They won't. I need to address on this final part of Article 3 something that's new. Not content with independent counsel Starr's 11 charges, the majority seems to have decided it needed one more. And somehow they have added as an obstruction of justice the president allowing his private attorney to make a statement about the definition of sexual relations in the deposition that they say the president knew to be false. Well, we have dealt with twice the issue of whether this definition makes enough sense for anyone to understand. And we have dealt with the issue of how it helps this process be fair for the majority to add charges over and over about the same basic issue, the president lying about sex. But there is one new point to make. When the majority was on one of its frolics to expand this inquiry into new matters, there was a raucous raised to take the deposition of Robert Bennett, the attorney apparently involved in this article's charge. But just as fast as the majority scheduled that deposition, it canceled it. That was more than a little bit unfair when it was planning to make a charge never before known based on testimony it then conveniently engineered never took place. Mr. Chairman, Article 4 raises the specter of abuse of power. We saw this charge back on September 9th in the independent counsel's referral, but then we never saw it again until this week. The term abuse of power does invoke the memory of President Nixon's offenses in 1974. Yet those who have appeared here as witnesses with Watergate knowledge, former Attorney General Elliot Richardson, Judge Charles Wiggins, Father Robert Drinan, former member Elizabeth Holtzman, former member Wayne Owens, Watergate prosecutor Richard Benvenisti, House Judiciary Committee staff member William Weld, all could tell you that the acts you are considering today are not the same. In Watergate, abuse of power was proved with tapes of President Nixon telling his aides to get the CIA to stop an FBI investigation, to create a slush fund to keep people quiet, with tapes that you can hear him directing the break-in of people's offices, or to get IRS involved in going after political enemies. Here, the charge stands on tapes of Monica Lewinsky and Linda Tripp talking about going shopping. As it is presented to you in 1998 and as originally contained in Mr. Starr's grounds 10 and 11, Abuse of power means that the president lied to his staff or to the people around him about the same inappropriate relationship with Ms. Lewinsky, knowing that they might repeat those lies, and that the president then violated his oath of office because he and his attorneys tried to protect his constitutional rights by asserting privileges of law. Members of the committee, I know you have only had one night to review the proposed articles of impeachment. We on the Democratic side did. But as you did, I hope you saw how the majority proposes to dress up this almost frivolous charge. Look on page 7 of the draft articles. You will see the impeachable offense is that by denying his affair to the cabinet and to his staff, who then also made public denials believing that to be the case, the president, quote, was utilizing public resources for the purposes of deceiving the public, end quote. If this were not so serious a proceeding, I would have thought that this was included for the humor. As to the substantive charge that misstatements to the staff might be repeated in the grand jury or even to the public, this article of impeachment merely repeats in another form the same charge that the president wanted to conceal his private sexual relationship from anyone and everyone he could. As my daughter would say, duh. As the committee takes up this proposal, keep focused that this was not an attempt by a president to organize his staff to spread misinformation about the progress of the war in Vietnam, or about a break-in in Democratic headquarters at the Watergate, or even about how funds from arms sales in Iran were diverted to aid the Contras. This was a president repeating to his staff the same denial of an inappropriate and extremely embarrassing relationship, the same denial that he had already made to the public. Does this article of impeachment envision that the president, having already made public denials, would have then gone inside the White House and told the staff something else? However wrong the relationship or however misleading the denial was, it is not nearly the same as those other examples I have just given you. I heard Mr. Sensenbrenner say 2 days ago that there was no difference between a president lying about illegal bombing in Southeast Asia and about a private sexual affair. But members of the committee, let us not lose sight of the fact that unlike the case in 1974, Bill Clinton's alleged crimes are not those of an errant president, but are that of an unfaithful husband. Mr. Chairman, I hope you can agree with me in 1998 that these statements by the president are not proper grounds for an impeachment. Your words in 1987 explaining the untruths told by government officials in the Iran-Contra matter, something far more important to America than the president's private sex life, I think answer completely the article of impeachment today. Speaking not about testimony under oath, but about statements made in public, you said then, and I quote, "It seems too simplistic to condemn all lying. In the murkier grayness of the real world, choices often have to be made. All of us at some time confront conflicts between rights and duties, between choices that are evil and less evil. And one hardly exhausts moral imagination by labeling every untruth and every deception an outrage," end quote. Mr. Chairman, the president's trying to hide his totally inappropriate relationship to his aides and to the American public seems to be exactly the, quote, murkier grayness of the real world, end quote, about which you were eloquently speaking. As to the ground for impeachment that the president had the audacity to assert privileges in litigation, White House counsel Ruff did a complete job of disproving any possible issue the committee could have. Let me only add one note, that it still remains shocking to me, as I hope it does to all the lawyers on this committee, that you would even consider as an article of impeachment an assertion of an evidentiary privilege by the president on the advice of his lawyers and the White House counsel that was found to exist by a judge, that could ever be grounds for an impeachment. I have heard the majority state that a president should not be above the law, and yet this proposed article would place him below the law that gives every American the right to assert legally accepted privileges without fearing being thrown out of his job. Members of the committee, in light of the high threshold and the need for clear and convincing evidence, what can you make from the fact that the minority staff is demonstrating that the evidence is so slight that it does not even exist on many of the charges? After all, you have 18 boxes from the independent counsel and 450 pages of a referral. But that's exactly the point. Members, you now know that all you have before you is the material that was sent by the independent counsel. The committee has gathered no information on its own. On November 19th, this committee heard an entire day from independent counsel Starr, who sent you the material. Many majority members criticized Democrats for asking Mr. Starr and his deputies about their conduct instead of about the facts. Mr. Chairman, it would have been totally inappropriate to ask Mr. Starr about the so-called facts of the case. He admitted on that day that he was not a fact witness and was not even the person who asked any question in any deposition or in any grand jury appearance. What Mr. Starr admitted he was, however, was the man who made the decisions concerning whether a referral should be sent to Congress, when it should be sent, what it should include, and what it should omit, how it should be written, and what it should charge. In fact, this is how Mr. Starr described his responsibility.
In the end, we tried to adhere to the principle Congressman Graham discussed on October 5. 30 years from now, not 30 days from now, we want to be able to say that we did the right thing. At the end of the day, I and no one else was responsible for our key decisions.
Members of the grand jury sign off on this referral.
No, we did not ask the grand jury to review the referral.
Given that they didn't sign off on it, did they vote on or review the allegations, the credibility determinations, or the inferences that the referral draws?
No, we did not ask the grand jury to make specific judgments on specific witnesses. These were our assessments. These were our evaluations.
Thank you very much.
It is precisely because there is such a large gap between what Mr. Starr's charges state and what the evidence actually shows that we asked those questions. Because as Mr. Starr told you when he sent you his letter on September 25th, his conduct and that of his office bears on the substantiality and the credibility of the evidence. And his letter you may find in tab 5 of your exhibits and on the chart that we have put before the room. As this committee has chosen to receive Mr. Starr's referral and its conclusions and the material he decided to send in determining whether there is clear and convincing evidence to support impeachment, and as we claim, indeed I think as the minority staff has proven, that such large gaps exist in the evidence,